everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have an editorial for our discussion that has been taken from the Indian Express that talks about the challenge that has come up to the Supreme Court regarding the Citizenship Amendment Act, and where does the case stand as of now will be discussed here. Then we have news updates and legal news for the day. Before moving further, I'd like to congratulate two students, Hitesh Kukreja, and we did not get the name, it's SVJJ, the profile name is, for giving the right answer in the previous newspaper analysis that yes, it is Mandla, it is a district in Madhya Pradesh that has now been acclaimed to become country's first fully functional literate district. So the answer is correct. Great, guys. So with this, let's move forward with today's analysis. So the Supreme Court to take up the CAA challenge. Basically, the CAA, as we all know, is the Citizenship Amendment Act. So a three-judge bench headed by Justice UU Lalit, now as we all know, is currently the Chief Justice of India, the recent one, is set to hear the case about the Citizenship Amendment Act challenge. The challenge rests on the following two issues. Firstly, that the Citizenship Amendment Act 2019 states that the migrants of three countries, which are these three countries, Afghanistan, Bangladesh, and Pakistan, belonging to five religions. And which are these five religions? Hinduism, Sikhism, Buddhism, Parsi, or Jews, shall be given asylum and citizenship in the country. So asylum, by that we mean that they can come and they can take kind of a refuge in India, and they would be given so, and with period of time they will be given the citizenship of India as well. Secondly, the challenge brought against the act is that it is violative of Article 14 of the Indian Constitution. Now, when we talk about Article 14, it is a fundamental right and talks about right to equality. And it says that if at all we are only giving this right to asylum and citizenship to people belonging to only these five religions, that is Hindu, Sikh, Buddhist, Parsi, and Jews, and if we are overlooking all the other religions, and specifically if we talk about the topic of debate here is the Muslim religion, then this will be against the Article 14, or basically right to equality for those, for all those people who are being persecuted. So the Supreme Court has come up with two-pronged tests to resolve the issue. And meanwhile, we used to study Article 14 in our law schools as well. We used to understand that there are definitely two things that we need to consider. Firstly, that if at all any differentiation between the group of individuals takes place, it must be based on intelligible grounds, which meant the intelligible differentia. That is, that there should be a reasonable classification, if at all we are making any classification, for the better application of Article 14. And that the differentia must have a rational nexus to the object sought to achieve by the act. So, for example, this XYZ is the particular object or the particular goal of an act. So whatever differential that we are making, whatever reasonable classification we are making, it should be in the lines of achieving this XYZ goal of the act. And if at all there is no rational nexus or no rational connection between these two things, that is the goal of the act and the reasonable classification, then it shall not stand on the merits of Article 14. So hence, for the law to stand up to the test of Article 14, the same must make a reasonable class that shall be governed by the law and only law. Then the opposition in this case has raised the question that if granting asylum and protection is the sole goal of this act, then why is religion a yardstick to the same? Definitely, there cannot be seen any particular reason or rationale behind this. Though the government, after giving this after giving this reason for bringing in religion, they have said that in these countries, be it Pakistan, Bangladesh, or be it Afghanistan, they say that the people belonging to these five religions that they have covered in CAA 2019, they are more persecuted and the Muslims are safer as compared to them. But we definitely know that that is not the case, because if we talk about, Bangladesh, so a lot of Rohingyas, even, Myanmar has not been included, but if at all we talk about the people coming from Bangladesh also every now and then, and even the people who are coming from Pakistan and Afghanistan also, many of them belong to Muslim religion and they have been persecuted in their own country. So that is why here this could be a valid question as to why is religion a yardstick to the same, if at all the sole purpose is providing the asylum and protection to these people. So the government has stated that the May 2021 notification relating to the acceptance of the application of citizenship in certain districts had nothing to do with the Citizenship Amendment Act. But of course, that might be a kind of a cover-up that the government is trying to use. Let's see that what the future has for this. So what is to be seen is whether the challenge to the statute turns into an interpretation of the Constitution and how the same reflects upon the petition as well. With this, let's see what do we have for news updates today. Firstly, Australian Senate passes law for 43% greenhouse gas reduction. So Australian Parliament has passed government legislation in view of a pledge to reduce carbon emissions by 43% by 2030 and further bring it to zero by 2050. Secondly, Kalinga Institute of Social Sciences wins UNESCO's International Literacy Prize. So, Kalinga's Institute of Social Sciences in Bhubaneswar has won the prestigious UNESCO King Sejong Literacy Prize 2022 for its outstanding literacy program based on the recommendations of the international jury. Thirdly, NIESBUD, IIE, and ISB sign MOU. So the National Institute for Entrepreneurship and Small Business Development and the Indian Institute of Entrepreneurship signed a memorandum of understanding individually with the Indian School of Business to offer world-class management education through entrepreneurial programs targeted towards youth and job-seeking entrepreneurs. Fourthly, iSTEM initiative launched Women in Engineering, Science and Technology. So on the occasion of Teachers' Day, that was on 5th of September, the Indian Science, Technology and Engineering Facilities MAP, that is iSTEM, launched an initiative to strengthen the efforts of scientifically inclined women. It is a special drive for supporting women in engineering, science and technology. As we know that in many scenarios we have seen that the women participation specifically in the field of science though has been significant, but the number has been quite considerably low. So to bring that to an equal number, this initiative has been launched, which is called as WEST, that is Women in Engineering, Science and Technology. Let's see what do we have for legal updates today. Firstly, accused's offer of payment of ad interim compensation to victim cannot be a ground for granting bail, says the Supreme Court. So the Supreme Court observed that the offer of payment of ad interim compensation to the victim cannot be a ground for release of the accused on bail. And this was held in the case of State of Jharkhand versus Salauddin Khan. Secondly, legality of order setting defendant ex parte can be challenged in appeal even without filing application under Order 9, Rule 13 of the Civil Procedure Code, says the Supreme Court. So the Supreme Court observed that while challenging ex parte decree by filing an appeal, the defendant who had not filed an application under Order 9, Rule 13 CPC can argue ex parte proceedings against him was unjustified. So it is only when the application made by a defendant under Rule 13 of Order 9 of CPC is dismissed that such a defendant cannot agitate in the appeal against ex parte decree that the order directing that the suit shall proceed ex parte was illegal or incorrect, the bench observed. And this was held in the case of G.N.R. Babu, aka SN Babu, versus Dr. B.C. Muthappa. So this was all for today. We hope you liked the session. Thank you so much for staying tuned with LawSikho. You can download the PDF of today's slides from our Telegram channel. The link is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.